like me, I'm sure you've seen your share of police drama, TV shows, and movies. And there's always that scene where the police have captured the bad guy, put him in cuffs, and you hear those immortal words, read them as rights. Well, what are those rights? And how did they come about? And is the way they portray it in TV and the movies really the way it happens in real life? Well, I'm Robert Winters, and I'm a professor with the School of Social and Behavioral Sciences, Department of Criminal Justice here at Purdue Global University. Join me as we take a look at those rights, more commonly known as Miranda rights, and we separate fact from fiction. Now, in order to be able to understand Miranda rights and what they're all about, we need to have just a little bit of a background so we understand the context and how they came about. Miranda rights came about from a case known as Miranda v. Arizona, a 1966 U.S. Supreme Court case that ruled that an arrested individual is entitled to the right against self incrimination and have an attorney present during questioning under the Fifth and Sixth Amendments of our United States Constitution. Miranda also established a consistent standard for when a defendant's incriminating statements can be used in court. Well, then that says, why is that important? Well, Miranda ensures the voluntary nature of a suspect's confession or incriminating statements. This is important because under our system of criminal justice, incriminating statements, those are statements that are against the defendant's interest, must be voluntary in order to be admissible. Involuntariness is important because the court holds and the law holds that if statements are made voluntarily by a defendant, that means without any action by the police that would be considered to be torture or duress or any coercion or anything like that. Okay. The voluntariness of the statements means that that defendant is making the statement truthfully. Because who is going to admit to committing a crime that could end up with them in jail, or maybe in some cases even death, unless that statement was true? So voluntariness is very, very important. Now, in order to make sure that the statements are voluntary and that a suspect has been aware of what's going on, Miranda rights are triggered whenever there's going to be a custodial interrogation. And those rights include the ones that we're familiar with from TV and the movies. The right to remain silent, the knowledge that incriminating statements can and likely will be used against the defendant at trial, the right to have an attorney present during questioning, and the right to have an attorney appointed and provided to the defendant or the suspect at that point if the suspect cannot afford one. So, in short, you can say that custody plus interrogation, both of those two things, trigger the Miranda requirement. But then we have to look at what is custody and what is interrogation. Well, custody is either a physically detained person or a person is in such a setting that a reasonable person would feel that he or she was not free to leave the presence of the police officer. In other words, when you're arrested, when you're placed under arrest, the officer says, "I'm arresting you," or when you're handcuffed are two examples of what would be considered to be custody. So then what's interrogation? Well, interrogation are questions asked by a law enforcement officer whose purpose is to elicit incriminating information or reasonably calculated to elicit incriminating information from the person being questioned. Okay, a lot of fancy stuff. How does that play out in practical application versus what we see in TV and the movies? Well, what happens? Let's go ahead and take a typical example of what happens when the police pull you over and they ask you for driver's license, registration, and proof of insurance. Okay. Is that considered to be custody? Well, the law has held no, that the officer, that's just a mere detention, and the officer is allowed to detain you and you're to give him your information until the officer has conducted whatever investigation, whatever reason the officer pulled you over for. Okay. So now, what would be considered an interrogation? Let's take my example a little bit further. Let's say the officer says, "Can you please step up here on the curb?" And the officer is talking to you and asking you a bunch of questions while they're looking at your driver's license and your registration and so on. And the officer says, "So, where were you tonight?" Is this where you live? Where are you going? Did you have anything to drink tonight? How often? How much did you have to drink tonight? When was the last time you had a drink? Now, one could reasonably say that, hey, those questions about drinking, that could be considered to be interrogation because if I answer those, I'm giving potentially incriminating information that I've been drinking that night. Well, yes, in most cases, that's going to be considered interrogation. But does that trigger a Miranda warning? Well, no, because look what we have here. It's custody plus interrogation equals Miranda, triggers the Miranda warning need. Okay. So in the last example that I just gave, we have interrogation, but we don't have custody. And because we have one, but not the other, then in that case, Miranda warnings are not required. And if you answer the officer's questions, then you've gone ahead and given that information voluntarily. Okay. So, unlike our TV shows, okay, where the officer will be reading the suspect their rights right at the scene as they're cuffing them, in real life that doesn't happen because in that situation we had usually in the TV type of situations we have custody, but we don't have interrogation. So there we have Miranda rights, separating Miranda rights, fact from fiction. I hope you enjoyed this as much as I enjoyed presenting it to you. Once again, my name is Robert Winters, and I hope to see you in another video soon. Thank you. Take care. Bye-bye for now.